Legal, ethical and professional issues within the game industry. Contractual. Contractual obligations have following issues: employment, development, license, NDA, collaboration. Employment contract. Contract of employment usually defined to mean the same as contract of service. Contract of service has historically been distinguished from a contract for the supply of service. The expression altered to imply the dividing line between a person who is employed and someone who is self-employed. The purpose of dividing line is to attribute rights to some kinds of people who work for others. This could be the right to a minimum wage, holiday pay, sick leave, fair dismissal, a written statement of a contract, the right to organize in a union, and so on. The assumption is that generally self-employed people should be able to look after their own affairs, and therefore work they do for others should not carry within an obligation to look after these rights. Development agreement. Game publishers often hire games developers to create games for them. A development agreement is a contract that spells out the term of development deal. Terms. In this part of agreement tells how much the publishers will pay the developer, in what amount of time the developer has to develop the game. Ownership. This is important because you have to clarify whether the publisher owns the IP or the developers own it. Warranties. The developing company has to swear that it won't use anybody else's source code, and publishing company has to swear that it has the right to ask the developer to create this particular game. License agreement. When a publisher wants to make a game about a movie or something, the publisher and the movie IP owner execute a contract spelling out the terms of the license. What's paying license? The contract probably specifies that the publisher only has the right to make a game that works on Xbox 360 or PlayStation 3. The contract specifies what part of the world the publisher games will be published in. Publishers always want to worldwide rights, of course, but licensors often change them more for that. The term contract probably doesn't run forever. Most license agreements run on more than 5 years. NDA and confidentiality agreement. Non-disclosure agreement, disclosure agreement and confidentiality agreement are pretty much the same thing. One party, in order to do business with the other party, has to disclose a secret of some kind, a plan to make a particular game, or a new technology or process for making games, or a business deal that hasn't yet been publicly announced, and has to tell this secret to the other party. The other party agrees not to disclose the information, to keep it confidential, else damage will be the result to the first party. Collaboration agreements. They're both types of contracts, cover the most frequent types of contract in the mainstream game industry, but a lot of people are building indie games or hobby games, and for those folks a very important need is an agreement that covers the all important issues of ownership and compensation of creation of games that exist outside of the mainstream industry, games that might or might not ever generate any money. The major of hobby and indie projects fail. A huge factor in those failures is who's supposed to do what, and who's going to get what. A collaboration agreement sets forth in a clear term how the indie of hobby project is managed and controlled, who owns the IP, who the game is intended to be used, how many possible income is to be handed, and how termination of the project is to be governed. Legal. IP, intellectual property, copyright, trademark, patent, registered design. IP, intellectual property, Intellectual property (IP) refers to creation of the mind, investigation, literary and artistic works, are symbols, names, images, and designs used in commons. IP is divided into two categories: industrial property and includes investigation, patents, trademarks, industrial designs, and geographic indicators of source, and copyright, which includes literary and artistic works such as novels, poems and plays, films, musical works, artistic works such as drawings, paintings, photographs and sculptures, and architecture design. Since intellectual property is intangible, it is more difficult to protect than other types of property. However, intellectual property is stolen. It may be difficult to recover. Say, for example, a person comes up with a great idea for a new invention. If someone else steals the idea, the potential profit of the invention may also be taken away. Copyright. Copyright is a legal means of protecting an author's work. It is a type of intellectual property that provides exclusive publication, distribution and usage rights for the author. This means whether content the author creates cannot be used or published by anyone else without the consent of the author. Many different types of content can be protected by copyright. Examples include books, poems, plays, songs, films and artwork. In modern times, copyright protection has been extended to websites and other online content. Therefore, any original content published on the web is protected by copyright law. This is important in the digital age we live in, since large amounts of content can be easily copied and pasted. Trademark. A trademark is a distinctive sign indicator used by an individual, business, organization, or other legal entity to identify that the product or service to customers will eat which the trademark appears. Organization form a unique source and to be distinguish its products or service from those of other entities. A trademark is typically a name, word, phrase, logo, symbol, design, image, or a combination of these elements. This also a range of non-conventional trademarks comprising marks which do not fall into these standard categories, such as those based on color, smell, or sound. Patent. The term patent usually refers to an exclusive right granted to anyone who invented any new, useful and non-obvious process, machine, article of manufacture or combustion of matter, or any new and useful improvement thereof, and claims that right is a formal patent application. The additional qualification utility patent is used in the United States to distinguish it from other types of patents, but should not be confused with utility models granted by other countries. A patent is a form of intellectual property. It consists of a set of exclusive rights granted by an sovereign state to an inventor or their assignee for a limited period of time in exchange for a public disclosure of an invention. Registered design. A registered design is a monopoly right for the appearances of the whole or part of a product, resulting particularly from the lines, contours, colors, shapes, texture, and materials of a product or its ornamentations. These designs could be anything from a patterns or textiles or plates to the shape of a car or the design of a part of a product, such as a kettle handle. A registered design covers two-dimensional as well as three-dimensional articles and organization. Registering a design with the Intellectual Property Office gives you an extra legal protection. It gives you the exclusive right to make, use or stock any item incorporating your design, to take action against those who infringe this right. Gaming ethics. Video games are widely played for entertainment and amusement. In addition, they can act as an aid in relieving stress. Due to advertising technology, video games have evolved and grown into large empire impact. Those within this realm. Gaming ethics consist of following ethical issues: violence, rating, education, stereotyping, addiction. Violence video games is a massive debate, often centered on a topic such as video games graphics, violence, sex and sexism, violence and gory scenes, partial or full nudity, portrayal of crime behavior, racism, and other provocative and objectionable material. It can be agreed that engaging in video games does have many ethical concerns. Violent video games effect on children and adolescents is an indispensable tool for parents and professionals who want to have important knowledge to make wise decisions about video games use in the lives of children and teens. Ratings. The Pan-European Games Information (PEGI) agree rating system has established to help European patent make informed decisions on buying computer games. It was launched in spring 2003 and replaced a number of national age rating systems with a single system now used throughout most of Europe. Through the rating of games, it helps the parent of young children to pick the right game for kids. Through others are concerned that this rating system doesn't prevent people from acquiring video games that they considered too inappropriate for their ages, which is true. In 2010, the Supreme Court in US decided to hear a case about the criminalization of the sale of violent video games in children, but lucky this bill didn't pass. Education. Through the education perspective, these are different things gaming can teach us. Some are positive while others are negative. Educational video games are considered a type of serious game, as these games have a strong purpose other than pure entertainment. Stereotyping. The video game industry focuses forwards men more than women. Therefore, many people think it's stereotyping against women. This is true. However, men do play more games than women. However, games developers do add the woman side to it, being it able to create a woman character, stereotyping if games add an experience towards both genders rather than just one. Addiction. Lastly, through addiction, participating in a long amount of time in a video game has caused people to be addicted to it. As a result, they lose valuable time within their communities and miss opportunities from other activities that could be more beneficial for them. This is one of the major concerns that the video games industry is having. The problem being is that they want people to enjoy their games a lot, but then addiction comes and they don't want that. Otherwise, a lot of health claims comes along. So the ideal game is something that's fun, yet not addicting. Professional bodies: ELSPA, OK, IGDA, Women in Games, BAFTA and MEF. OK. LSPA changed their name to OK in March 2010. OK is the only trade body for the UK's wider interactive entertainment industry. We exist to champion the interest, needs and positive image of the video games and interactive entertainment industry whose companies make up our membership. IGDA, International Games Developers Association, is the professional society for over 10,000 video and computer games developers worldwide. It is incorporated in the United States as a non-profit organization. Its stated mission is to advance the careers and enhance the lives of games developers. In recognition of the wide-ranging, multidisciplinary nature of interactive entertainment, there are no barriers to entry. Any person who considers him or herself to be a game developer may join. Women in Games highlight academic and industrial perspective on a groundbreaking work in computer games research, games development and games education. Focused attention on issues of special interest to women in the games industry, and through the seek of address the games industry gender imbalance and develop a further understanding of games and game playing. BAFTA is the leading independent charity supporting, developing and promoting the art forms of the moving image in the UK, from film and television to video games and interactive media. MEF. MEF is a global community for mobile content and commerce. It is an organization for companies wishing to convert their goods, service and digital products via the mobile connected device into money. MEF provides competitive advantage to its diverse membership, shapes industry growth, connects through the leaders and spearheads groundbreaking initiatives which explore and promote profitable opportunities.